0DO. Present in the virtual courtroom, we have both parties as well as Ms. Van Dyken representing the plaintiff. The court did sign an order, I believe, yesterday allowing Mr. King to withdraw from the case. And this is Ms. Van Dyken's motion.
Briefly, Your Honor, yes, this is our motion. I had to renotice it. We sat here for 2 hours last time waiting for Mr. King, and he did not appear. Your Honor, this is very clear. Ms. Adams was to supply Mr. Adams all of the information necessary for him to access this Parent Plus loan. What she continues to provide him is just a payer's access. So he can make a payment, but he can't see what payments are being made, when a forbearance is being asked for, or anything. These parties were to make joint payments on this account. My client made his payment in November. Ms. Adams did not. I'm sorry, Mr. Adams made his payment in October. Ms. Adams did not make her half of the payment. She subsequently, on her own volition, asked for a forbearance prior to the November payment being due. And she didn't make a payment. It's her fault. These parties are going to start continuing to get interest on this account because she's not making her half of the payment. It's now in a forbearance, which my client doesn't have access to as to what reasons she gave for the forbearance. He's responsible for half of this loan. He needs to have the full and complete access that Ms. Adams does, and she needs to provide all of the information requested in our motion. I'm also asking for attorney fees, Your Honor, for the necessity in filing this motion, waiting here 2 hours next week, and handling this motion today. She is not following the judgment or the orders of this court, and so we're asking for attorney fees and sanctions against Ms. Adams. Thank you.
Thank you. Ms. Adams.
Unfortunately, I was not able to obtain an attorney. The attorney that I had on deck to appear with me this morning could not reschedule their case to be able to appear with me. Number one, I have provided everything that was requested to Mr. Adams. Yes, I did not make October's payment. I informed Mr. Adams this is why I did not. I didn't know that he wanted like full access, like the same passwords. As I told him before, the way the system is set up, if I give him access, give him the same thing, it automatically comes to my phone for a PIN code, and I'll give him that if that's what he wants. I was informed that when I gave him the authorized payer, that he can see everything. I made the forbearance because November's payment, because I know I wasn't financially able to make October's payment, I did the forbearance. The forbearance ends January. There's going to be 2 payments coming up in January for $65 and then for $85, $846. Those 2 payments should be one as a reduction. I informed Mr. Adams, just like I sent the letter saying that the payment reduction was reduced. I told him that before because I couldn't afford the $1,000 payment. And I asked him, I gave him a choice. We had a conversation. Hey, I can't afford the $2,000 payment. I'm going to request a reduction in payment. And I gave him 3 options. And the one option that I wanted to do was a 10-year repayment, but the other one was 25, and that's the one he wanted to go with. So that's the one I chose, which gave us a payment of $864.55. That's starting actually in January. But as you can see, as the statement made by Ms. Van Dyken last week, where there's a payment due at $65 because there are multiple loans, Parent Plus loans. That one loan is due January 10th, and the big one is due January 11th. And I was on the phone with Nelnet for like 4 hours total, on 2 separate days, trying to get this resolved, trying to get them combined. So, and she had initially, when I called them, she said that if you give him the access now, it's going to confuse everything. So we're trying to get everything all nestled up. And as Mr. Adams knows, I don't have a problem giving him any information he's requested. I thought giving him the authorized payer would suffice. If he wanted more, he could have just picked up the phone and asked me. I didn't know he wanted to see everything. So that's why I was screenshotting every single document of what that was in the portal. I told him everything. I've not withheld any information from him. If he wanted to, just like he requested information for all the disbursements, I don't have access to that. Our daughter has access to that. If he wants that access, he can pick up the phone and call her and she'll give him all the access. I gave him every loan, everything that I have, he's had, because I didn't even realize he wasn't getting access. Now I'm starting to repeat myself. But again, I'm not trying to withhold anything. I didn't even know that I was to appear in court the last time. I didn't know my attorney was not going to represent me for any of this. So my apologies to the court. My apologies to Ms. Van Dyken for waiting 2 hours because that was an inconvenience to me. My apologies to Mr. Adams. I have diligently tried to get an attorney, but I've not been able to do so. I am a commission person. So my fund, I don't get a guaranteed check, just like Mr. Adams. Mr. Adams is very aware of that. We've had several conversations about this. So again, I'm doing my very best. I'm not trying to withhold anything. Ms. Van Dyken has all the information. And I apologize for contacting you. I was by a couple of attorneys that I was calling to try to get representation. They told me, hey, send him everything they're asking for, strictly to Ms. Van Dyken's office, and maybe we could, since you're giving them everything, maybe everything's resolved. So I did that on advice of on 2 or 3 different attorneys that I reached out to, because they were not able to accommodate me for today. So I've done the very best that I can.
Ms. Van Dyken.
Your Honor, briefly, she just stated that there were 2 loans that she negotiated forbearance on. My client has no idea about that.
I didn't say that, Ms. Van Dyken.
Ma'am.
I didn't say there was 2 loans.
This is simple. She gives him her password, her ID, and he can log in. If she gets a 2-factor identification code sent to her phone, she immediately gives it to him. So he can see what has been done in this loan for $185,000 for their child, supposedly. And he needs to know, she can't unilaterally negotiate these forbearances. She can't unilaterally not pay her half, because that increases the interest. So the fact that and I remind the court, she and Mr. King brought the motion for spousal support and these payments. So he was in, and she knew about these payments, and they were forcing Mr. Adams to start making his, and they never disclosed that they weren't making payments during COVID. We had to bring that out. She never made a payment, and she still hasn't made a payment. So, Your Honor, it's all for naught. So,
all right, thank you. I as Ms. Van Dyken says, this is very simple. With the multiple hearings we've had, it's been very clear what was expected. I will find that the the defendant has caused, frankly, the attorney fees of Mr. Adams to be run up based on her failure to comply with the orders in this matter. I will order that she immediately turn over her sign-in information to Mr. Adams, and that she comply with any 2-factor authorization requests so that he can access that information, that she immediately provide proof that the payment was applied, that his payment was applied to the loan. Although I suppose he can see that online if he can get access, and that would take care of that. That be done within 3 days. And if that doesn't happen, then there will be a sanction of $100 per day for every day that doesn't happen. I will grant the request for attorney's fees in the amount of $500. I think that's reasonable based on the amount of time that the court can see that's been spent by Mr. Adams' attorney on this case. And Ms. Van Dyken, we will prepare that order.
I will, Your Honor. Could we have a time frame on the attorney fees? I know it's the holidays. I'm willing to go 30 days.
All right. Let's say 60 days.
Thank you.
All right. Thank you.
No,
I've made my decision. DM. Both parties are present in the virtual courtroom along with their respective attorneys. Ms. McClure on behalf of the plaintiff, Ms. Sierra on behalf of the defendant. We're here on a couple of motions filed by the plaintiff. One is a motion to quash subpoena, and the other one's a motion for a protective order. Ms. McClure.
Thank you, Your Honor. And these are interrelated motions, so I'll sort of address them at the same time, if that's okay. Sort of starting with the motion to quash subpoena, I think a more proper title to that motion would have been a motion to modify the subpoena. I think a lot of what is requested in that subpoena is relevant, and the defendant is entitled to that information. However, I have serious concerns about specifically the items of that subpoena that request pretty blatantly documents that would breach attorney-client privilege between myself and my client, and also the personnel file of another person who has nothing to do with this case. And I think that's incredibly inappropriate. So I would ask that the subpoena be modified to exclude the items as mentioned in my motion. And moving on to the other discovery requests, the interrogatories and the request for production. Again, there's duplicative information requested of my client. So he is asked in the request for production to produce the same information that's going to be supplied by that subpoena. Again, in addition to hosts of information that also would breach attorney-client privilege and are incredibly private in nature, including, HIPAA waivers, including appointment books, all of his messages, all of his pictures, just this vast quantities of information that would require him to spend hours and hours, I think probably dozens or if not hundreds of hours to collect, and are absolutely not relevant to this case. And then the interrogatories, again, sometimes ask for that information yet a third time. Specifically, the items that I think are completely irrelevant and or duplicative would be in the interrogatories, questions 4 and 8, and in the request for production, items 1 through 6, 8, 12, 20, 25 through 28, 31, and 34 through 46. So I would ask for the court to order that a protective order that the plaintiff not be required to comply with those items, and also that any information provided would be protected, especially any private information through a standard protective order that we're all used to seeing, where it's for the attorney's eyes only. And I guess I would just ask for specific and clear guidance from the court about what the court thinks is relevant information, because this just seems absurd to me, and I would really like some guidance on that. Thank you.
Thank you. Thank you, Ms. Sierra.
Thank you, Your Honor. Our response and pleadings are pretty thorough. I know the court reads everything, so I'm not going to bore the court with reiterating what's in my responses. However, I think it's very important to note a couple of things. First of all, the motion to quash is not a timely motion. It should be dismissed on its face. There was 18 days provided for that subpoena to for the clients with the subpoena. It was provided to plaintiff's attorney on November 2nd. The requests were due on November 20th. There were 18 days in which a timely motion could have been filed. No motion was filed during those 18 days. It was only after 10 days after we were supposed to receive the documents and we were working on a protective order that we received this motion. So the motion to quash should be denied on its face because it's not a timely motion as provided by the court rules. As it relates to the information about the third party is Mr. Rambant's paramour, and that was an affair that started during the marriage, and we don't know how far it went back. It's absolutely relevant information. As far as attorney-client privilege, plaintiff disclosed privileged information by communicating with his attorney through his work email. He cannot now avail himself of the attorney-client privilege. That is set forth in Stavali v. Stavali 332 Mish App 556. It's very clear there's no privilege there with that communication. As it relates to Mr. Rambant's communication from his email, I do believe there's relevant information in that email, in those emails, and I think that my client deserves to have that, and it's important for the court so we can figure out what's actually going on in this case. As far as it relates to the as far as it relates to the motion for protective order, I I don't know what we're going to get back in these subpoenas, so I don't know if we're going to actually get any of this information. So I don't think that it is unnecessarily burdensome or duplicative to the extent that Mr. Rambat shouldn't answer these questions. The interrogatories and the request for production of documents that I sent are standard requests. This is a divorce case where Mr. Rambat has alleged that my client had an affair when she was sexually assaulted, which is, I don't even have words to describe that, and which is fascinating to me because he's been having an affair for quite some time prior to him filing for divorce. So I do think that, especially as it relates to some of these things that, Attorney McClure is saying that they're not relevant. They are relevant. We're asking questions about what has been spent on the paramour, communications with the paramour. These are all relevant questions. This is a divorce case that's hotly contested with extramarital affairs. There's a lot of moving parts here, and we need to really look at what's going on here. So I would request that both of the motions be denied.
Thank you. Ms. McClure.
Yes, just briefly in response to that, these parties have been separated for a long time. And yes, my client is in a relationship and he denies that he was in that relationship before the parties were separated. But as this court knows, many people are separated and move on with other relationships before the actual filing of divorce. And I guess I take issue that this case is hotly contested. The parties had a mediation that was actually very productive. And I guess it's become hotly contested when someone says it is. I guess that's what makes it so. But these parties don't have a lot of assets and they don't have they're not that far apart. And when we left mediation, I felt positive about where this was going to end because there was not that much at issue. And so I fear that this sort of witch hunt that they're engaging on is going to indeed make a case hotly contested when it shouldn't be for people that are, I don't want either of them to take offense, but pretty much, working class folks, these are not high income people. And this is going to go in a very bad place for them if myself and Ms. Sierra have to spend the hours it's going to take to process this information. And then my client also is spending the hours it would take to gather this information. So I guess I'll ask the court, we're at your mercy, essentially. Thank you.
All right, thank you. I will deny the motion to quash as not timely. I will grant, however, the protective order. I'm not completely closing the door on the duplicative, et cetera, questions. I think if those are not answered to the satisfaction of the defendant, then those can certainly be brought up again for answers if they're not complete enough. But I certainly don't want to run anybody's attorney's fees up in this case unnecessarily. Anything else?
No.
Well, Your Honor, I guess specifically which are you granting my request as to all of the items I mentioned?
Yes, the protective order.
Thank you.
The protective order, yeah.
So you're still requiring him to produce all that information. You're only granting the protective order.
Yeah, I'm granting the what you asked for in your protective order. Motion for protective order.
Okay, thank you.
Okay, all right, thank you. Parties as
Thank
well
you.
as their respective counsel. Mr. Hexel on behalf of the plaintiff, Mr. Cox on behalf of the defendant. And we're here on the defendant's motion for specific parenting time and to modify child support. Mr. Cox.
Thank you, Your Honor. Your Honor, this case is an unfortunate example of what happens when you decide not to retain an attorney. I know Mr. Strang regrets that decision, but it was a decision he made. And ultimately, I think, and I admit that this is a bit tangential, but I mean, let's just say he didn't do very well in the property settlement, but nonetheless, we're stuck with this parenting time paragraph that says these folks are supposed to somehow, be able to come at an agreement or come to an agreement relative to parenting time. And Judge, in talking with my client even this morning, I'm asking myself, what is it that has got you depicted as someone who isn't, a person who's a safe, reliable co-parent? Judge, my client has no criminal history. He has no CPS history. He's never been to jail. There's no alcohol or drug problem here. He's just a guy who, unfortunately, I think made a bad decision not to hire counsel and thought and hoped that things were going to work out well for him. But nonetheless, he's stuck with this horrible parenting time scenario. But nonetheless, as dramatic as that may sound, I don't think we're that far off, Your Honor. I don't know if I'm speaking out of turn, but I think that counsel and I both agree that a referral to the front of the court would be appropriate to take a look at parenting time and child support. Certainly, I think that we agree to. I think in fairness, it should be divided by the parties. But with that said, Your Honor, my client was enjoying every other weekend. And I admit, Judge, it was only for a couple of weekends, but had a great time with his kids. And then we filed this motion and she stopped the parenting time altogether. So, Judge, I think in fairness to my client, he should have at least every other weekend. And maybe we're asking for a Wednesday dinner visit, at least while that front of the court investigation recommendation is pending. Again, there is no reason to point to, and this whole notion that he was somehow an uninvolved parent or a non-caring parent is nonsense. He was a co-parent, Judge. And again, the optics for him look bad because he just didn't get his own lawyer. But we're at where we're at. And I think the fair result is to go ahead and award my client every other weekend until we can get that recommendation from the front of the court back. Thank you, Judge.
Thank you. Mr. Haxel.
Thank you, Your Honor. I outlined some of the issues that were going on in this case in my response. There's been concerns regarding the parenting time. He's smoking marijuana around the children. There is not a strong bond between these children and Mr. Strang at this point. We need to rehabilitate that. Ms. Strang did attempt to have some weekend overnights. It went horribly. The children came back and behaved poorly, reported things that were going on that were concerning, like marijuana paraphernalia, smoking marijuana in the car. The children don't necessarily want to go with him right now, which is problematic, and we need to improve that. Ms. Strang is not trying to prevent all parenting time, but we need to do a step program while the front of the court evaluation goes on. So she would propose that we start with some 6-hour blocks, make sure that that's going well, and then increase it from there while this goes on. She does have an established custodial environment. He's had little time with the children for almost a year now at this point. And that's what we're working against.
Thank you.
Judge, brief response.
Yes.
I appreciate the hyperbole, but there is zero evidence to back up the outrageous claims that Mr. Hexel is making. My client was an involved parent. He wants to be an involved parent, and there is nothing that disqualifies him from having at least every other weekend. Thank you, Judge.
All right. Thank you. I think at this point that pending the front of the court investigation, and I will send it. It sounds like there's a stipulation of that. I'll have the parties split the fee. Investigation regarding parenting time and child support. As far as parenting goes, pending that front of the court investigation, I don't know who to believe here. And I will always sort of lean to it when I have a question to the children. So I think I will start out with a couple of, actually I'll do every weekend for 6 hours on either Saturday or Sunday, and hopefully the parties can figure out what day works for them for like 2 weeks. And then after that, go to the alternating weekends. And then hopefully the front of the court will get something out with a recommendation.
Judge's clarification, I'll draft the order. Did you say either Saturday or Sunday for 6 hours for 2 weekends, and then after those 2 weekends are completed, then we start every other weekend?
Mm-hmm.
All right.
Yes.
Thank you, Judge. Appreciate that clarification. Thank you.
All right. Anything further?
Your Honor, can we request a prohibition on marijuana use while the children are in the defendant's care?
Yes, I think that's appropriate.
And then
not an issue, but we're certainly happy to agree to that. That's not a problem.
Well, and I would include alcohol in that too. It's not an unusual thing.
And then would it be appropriate to use Our Family Wizard for communication?
Mr. Cox?
Judge, I never have an objection to Our Family Wizard. But can I just back up a second? Is the no marijuana or alcohol applicable to both parties then? Because my
Yes.
client has no
Yes.
alcohol or marijuana history other than
Yeah,
Mr. Heckler's
it doesn't
remarks.
matter.
Okay.
Neither party should
Sure.
use substances while the children are with them.
All right, very good. Thank you, Your Honor.